I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start, the application is based on the affidavit of Honorable David Munya Matenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of urgency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter-parties hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024 before the court in Nairobi, and E015 of 2024 in Kerongoya. We immediately, upon learning of the orders that had been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my lady, sought several prayers. One was that we wanted to have that application certified urgent. Like in their case, our application was certified urgent. Again, we asked that the court considers hearing the application outside the normal court hours, including a possibility of being heard on a Saturday. My lords and my ladies, that prayer was not granted. We also, as a third limb of our application, asked that the court considers granting an ex parte order staying the decision of the Honorable Justice Mongo and the Honorable Justice Waita in the Nairobi matter. Again, my lords and my lady, that prayer was not granted. What followed was then the court, as would be the normal practice of that court, gave directions on how this application was to be dealt with. That is how we ended with the date of 22nd of October 2024. And why this is important, why is it their case that when they file an application and get orders, it is convenient, it is okay, there is justice. When they get another order in Nairobi, it is okay, there is justice. When we get an order merely certifying our matter as being urgent, then there is, all hell breaks loose. And we're saying, if only our colleagues had sought to present this material before this court, we would not be talking about what we're talking about now. It would have been manifestly clear that we were here on account of an application. My lords and my lady, I've had very strange submissions coming up this afternoon. Submissions including that at the ex parte stage where the court is supposed to be giving directions, the parties expected that the court to have been given notice. Since when, my lords, do the courts in this division, and indeed any other division, attend to matters under certificate, and at the ex parte consideration of those orders, invite parties for hearing of those orders? Why then do we call them ex parte? That submission, my lords and my lady, I repeat, is not for the consumption of this court. That submission can only go to serve an audience that is outside this court, because the people in this court are fully aware of the rules governing the conduct of matters in this court. But also, allow me a few more minutes just to point out a few other areas which then would speak to the reality of why then the omission of this material fact is then now being used to place this insinuation that the court either did something that was untoward, or the Honorable, the Deputy Chief Justice did something that is untoward. My lords and my lady, at paragraph D, the respondents in the application say, subsequent to the reference of a matter to the Chief Justice on the 18th, the petitioners reasonably expected that once the Chief Justice issued directions on the file regarding empanelment, the petitioners would also be invited for mention before the bench for directions as was directed by the Honorable Judge. If they didn't have an application, on what basis, therefore, was an order going to be issued to them? One would have expected that that would be something that would come from a party not represented. But a party represented would certainly be talking to an audience other than this audience. At paragraph G, my lords and the lady, they say they now have a direct accusation on her ladyship, the Honorable Deputy Chief Justice, say that the Deputy Chief Justice violated Article 1, 10, 27, and 50 of the Constitution in ordering this bench to hear and determine 3 matters in which conservatory orders had been issued against the government of Kenya and its organs, namely, there is no such order that came from a perusal of the file would speak for itself. All that the Honorable, the Deputy Chief Justice did was to constitute the bench. And in anything, this same bench is a bench that has been constituted by the Chief Justice herself. Questions that we ask ourselves: why is it that when we appeared before this very bench last week on Tuesday, on the hearing of their own application, we sat up to midnight? Today, because it is the issue is on the other side, it becomes irregular. That cannot possibly be a parity of arms when you're dealing with a question of justice. Why is it that when they went all over asking for orders, and this speaks to why there are only 2 matters that came before this court, they filed a number of cases. In those other cases, there were no orders. What business did we have filing applications in those matters? We only felt that we were aggrieved with these orders specifically because the effect of those orders were to suspend a provision of the Constitution. And that's why it's important for us that we deal with them. As we seek to deal with them, the only way that the rules of this court establish is that we make an application. My lords and my lady, I look at, finally, I think their ground number L, that they also sought to know the circumstances that led the Chief Justice to delegate to the Deputy Chief Justice. That I think has been spoken to. My lords, my ladies, what then comes out is that if our counterparts had been candid with the facts in the file as they speak, we would not be wasting time as we are right now. We would have had an opportunity to speak to the matters on the basis of the accuracy of the files. We would not be casting aspersions on the court as we have seen. We would not be casting aspersions on her ladyship, the Deputy Chief Justice, as we have seen. We will not be casting aspersions on the Chief Justice as we have seen. My lords and my lady, I repeat that submission is meant to achieve 2 reasons, and 2 reasons only. 1, to delay the proceedings that are before you today. We have an application, and at the right time we'll be seeking an existing public heart. And number 2, to then create this negative impression, which I suppose is meant to be used at a later stage. I rest my case.
Thank you, my lords and my lady. My name is Morigara. I need to submit only on 2 points of law which were actually articulated in support of the application. And these were that the proceedings before this court touch on the Bill of Rights, and they are vitally important that we should actually not be seen to flout the Bill of Rights. The Bill of Rights is chapter 4 of our Constitution, runs all the way from Article 19 to 50. But I wish to remind the court that the Bill of Rights applies to every party that comes before the court, and it's not just one party. The proceedings we have before the court are very important to the petitioner. They are equally important to the respondents. And it goes without saying that over 50 million Kenyans actually have an interest in these proceedings, and this is the reason why the agency has been certified both ways. My judges, aspersions have been cast on the bench so as to call for this recusal and application of Article 165(4), that you're being drawn into a conspiracy to commit injustice because there is no emergency that requires you to hear this matter as a matter of emergency. Far from the truth, the two applications that are before you to set aside the conservatory order are as important as the applications that led to the granting of those orders. Therefore, the hearing of those applications must be speeded up, and we are able to move with the matter ahead. You've also been accused of being enlisted in service of the violation of the Constitution. Again, far from the truth, because this is an allegation being made against you, while the position of the respondents is that justice must be served expeditiously and as required by our Constitution. Finally, Article 165(4), which uses the word assign and not appoint. Inasmuch as this is a constitutional responsibility for the Chief Justice to assign, it is purely administrative. The word used is not appoint. We are using other words like empaneling and what have you. But sorry, the word used is assign. And therefore, if the Chief Justice is not able to assign, nothing stops the Deputy Chief Justice from making the assignment. That is number one. Number two, where it is expressly provided in this Constitution that in the absence of the Chief Justice, the Deputy Chief Justice would act, relates to Chapter 9, when the Chief Justice is dealing with the executive. In this particular instance, we are dealing with a judiciary where the head of the judiciary is the Chief Justice, deputized by the Deputy Chief Justice. So I also urge you to find that in fact, there was nothing wrong with the Deputy Chief Justice in the absence of the Chief Justice assigning the judges who were to deal with these two applications that were before them that particular day, and the next applications which had been filed previously. Thank you.
My Lord, in 2 minutes, my Lord, as you retire to consider the application, Nilemo is my name, my Lord. I would invite you to consider Article 259, my Lord, Sub-Article 3, and particularly, my Lord, B and C thereof. And if you allow me, my Lord, I will read it out. And it says that every provision of this Constitution shall be construed according to the doctrine of interpretation, that the law is always speaking, and therefore, among other things, B, any reference to in this Constitution to a state or other public office or officer or a person holding such an office includes a reference to the person acting in or otherwise performing, my Lord, underline, otherwise performing the functions of the office at any particular time. My Lord, it's not disputed that the CTA was out of the country, and that, my Lord, the DCJ was performing the functions, my Lord, of the CJ at that particular point in time. And my Lord, our attention has been drawn to the communication from the CJ that had particularly asked the DCJ to take charge. My Lord, therefore, Article 259 3B provides an answer to the question that is before you. And my Lord, lastly, I'll read Article 259 3C, which reads, my Lord, and it says, a reference in this Constitution to an office, state organ, or locality named in this Constitution shall be read with any formal alteration necessary to make it applicable in the circumstances. My Lord, the circumstances before you were that the CJ was not available to give the directions or assign the bench. What the DCJ did, my Lord, was applicable in the circumstances. I invite you, my Lord, to refer to that provision when you be making your ruling. I think.
My Lord, I represent the Speaker of the Senate. My Lord, allow me to make very brief submissions without repeating what my colleagues have said. My Lord, allow me to start by quoting Article 145, paragraph 7 of the Constitution, to just contextualize the reasons for our application on Friday last week. My Lord, if you look at the provisions of Article 145, paragraph 7, my Lord, the impeachment of a deputy president is a serious national stability matter. My Lord, because after a vote by the Senate, in accordance with Article 145(7), the deputy president, my Lord, it says at least 2/3 of all members of the Senate, when they vote to uphold any of the impeachment charges, the president shall cease to hold office. In this case, as contextualized, the deputy president, the former deputy president, in this case, Mr. Gachagua, ceased to hold office. My Lord, look at it also in the context of Article 22. My Lord, this former deputy president, in exercise of his right in the Bill of Rights, my Lord, moved the court by way of a petition. My Lord, on Friday, that 18th of October, 2024. My Lord, conservatory orders were issued, which, in accordance with the petition, with the respondent's perspective, appear completely problematic. And my Lord, they required immediate intervention in terms of the respondents, my Lord, moving the court. Because, my Lord, the flip side of Article 22 is that whereas you have a right to file a case in court and seek conservatory orders in accordance with Article 23, paragraph 3A, a conservatory order which is discretionary, it means you are suing a respondent. Well, that respondent equally has a concomitant right to move to court, to interfere, to set aside, to ask the court to vary that conservatory order. My Lord, the grant of that conservatory order is discretionary. So, my Lord, there is nothing cast in stone in terms of the respondent, my Lord, coming to court to make an urgent application for the setting aside of that conservatory order. My Lord, there is also nothing strange for the court in public interest. My Lord, for the court in public interest, having looked at the grounds of this application to set aside these conservatory orders, my Lord, for the court to apply Rule 3 of the Mutunga Rules, my Lord, to make a just, expedient, and my Lord, proportionate decision in terms of directions on how to dispose of this matter. My Lord, again, under Section 60 of the Evidence Act, we all need to take judicial notice of the fact that my Lord, now we have the e-filing system. My Lord, when such extraordinary matters come to court, my Lord, the court is empowered. My Lord, at any time, my Lord, at any time of the day, my Lord, at any time, to access the system, and my Lord, to give appropriate directions for the expeditious resolution of this dispute. My Lord, they benefited from these orders on Friday. My Lord, unlike them, my Lord, we had the courtesy, because my Lord, we saw the court orders in the social media, and we responded accordingly. But my Lord, unlike them, we were courteous enough to serve the orders which were issued by this court to the respondents. So it cannot lie in the respondent's mouth to say that they have been ambushed to come to court, to the extent that they come to court and say that we are acting under protest. We did serve them with these court orders. My Lord, on the last aspect of that point is that, my Lord, then this petition, who has come to court under certificate of urgency, my Lord, having absented himself on at the Senate on Thursday for health reasons.
May I please?
I think that is okay. That is good.
My Lord, I'm just winding up, Lord, to emphasize the
But he did
contradiction.
not absent himself. Sickness is not absenting himself.
My Lord, I can rephrase. My Lord, I can rephrase. My Lord,
But
this
you can
petition.
as well avoid it.
Yes, my Lord. This petition.
May I say he apologized?
Let him avoid it.
Yes, yes.
Let him
Yeah, my
avoid
Lord, I'm
it.
avoiding that.
Yes, yeah, he has avoided it.
Justice administered without mercy and wisdom is not justice. Here you are talking about someone who is in his 60s, he's saying he's sick, he has cardiological problems, and you come and play it down. These are principal advisors to the government. They must be condemned.
My Lord, can I now conclude?
Have you drawn that?
Yes, my Lord, I was making a contradiction by saying that the petitioner was able to access the court expeditiously, and that the court was able to grant him conservatory orders on Friday. My Lord, the same petitioner cannot then come to court and complain. My Lord, complain when, my Lord, the Chief Justice, my Lord, the Deputy Chief Justice, my Lord, in public interest, and given the extraordinary nature of this matter, my Lord, gives directions that this bench be constituted for purpose of determining the underlying question. My Lord, the petitioner cannot probate and reprobate, can't speak on both sides of the mouth. So, my Lord, the other extraordinary nature of this matter, my Lord, is that the petitioners have filed a multiplicity of suits. My Lord, you have heard that there were 3 cases in Ikerugoya alone. My Lord, other cases were filed in Nairobi. My Lord, Kenyans, my Lord, this is the consumption of justice. My Lord, just a few days ago, the Chief Justice had appointed this bench to determine these matters for the satisfaction of Kenyans. My Lord, in the public domain, Kenyans are aware that this bench has been appointed. So, my Lord, what is wrong? What is so different? What is so strange for the Deputy Chief Justice when the Chief Justice is away? Again, for the same reason, for purpose of expediency and my Lord, for purposes of laying a multiple basis for consistency in judicial decision making, for these matters to be brought before this bench by way of a direction in terms of uses being used of this matter. So, my Lord, I don't see anything extraordinary. My Lord, as I wind up, the petitioners have just simply cast aspersions to the process of appointment. There's nothing cogent. Lord, I don't see any integrity issues with respect to the handling of this matter by the Chief Justice. I don't see any integrity issues with respect to the handling of this matter by the bench. So, my Lord, our plea, my Lord, our sincere plea is that the underlying dispute with respect to the setting aside of the conservatory orders, my Lord, in accordance with the directions which were issued, should be urgently determined, my Lord. My Lord, in public interest. Thank you.
My Lord, Madam,
my Lord, for the fifth respondent, I'll be very brief. I just wish to
Just remind us on
Yes,
the-
Dr. Kamoto, I think for the sixth respondents now, with the new order. First, I wish to set the record straight in terms of some misrepresentation that has been made with regard to the decision cited, the Reina Conchera decision. When the petitioners were submitting, they were not aware that I am one of the petitioners in this matter, and that I am fully versed with the entire set of facts. So they misrepresented that the matter is not active. Nothing can be further from the truth. This matter is active. It was mentioned on the 24th of September 2024 before a new bench that was constituted following the accession of the honorable judges who were previously dealing with it, and it is due for further mention on 30th of October 2024. So the decision remains solid in terms of its capacity to persuade you not to depart from it, because no reason has been supplied, save for the misrepresentation that it should not be utilized. Now, allow me, my Lord, to make reference to the High Court Organization and Administration Act in light of the issue that has been raised on the sittings of the court. I will briefly cite verbatim Section 10 on the sittings and recess sessions of the court, where it is put as follows: that the court shall subject to subsection 2, 3, and 9 sit continuously for the trial of criminal cases and disposal of civil and other legal business of the court. There is no disclaimer whatsoever with regard to the time that the court should sit. So the court can sit at any point in time, day or night. Indeed, today, when dusk came, I was apprehensive that counsel for the petitioners might leave, since the court is sitting past working hours, presumably. So the point that must lab home is that nothing prevents this honorable court from sitting at any time, such that then the issue of when the court sat, when the files were transmitted, when the orders were released, whether on Saturday, whether on Sunday, though it has not been shown that is what transpired, the court has liberty to sit on such occasions if need be. With regard to the issue of the empanelment by the Deputy Chief Justice, again on this account, the petitioners have misapprehended the import of Article 165(4), because what is fundamental is that there be a substantial question of law, and that question of law is certified on the discretion of a High Court judge. What that means is that the same issues that are being heard here today could have been heard by even a single judge, if at the discretion of the judge who handled the matter reasoned that there was no substantial question of law. So what the Honorable Chief Justice or anybody else capable of exercising the powers within the office of the Chief Justice does is administrative. All the High Court judges are qualified to deal with matters of such nature. All of them. So assigning one or the other is routine. It is purely administrative. there is nothing that is exceptional intellectually in terms of requiring a special exercise of powers when it comes to dealing with that aspect. So in a nutshell, I would wish that, to point out that in a hurry to come to court, the petitioners even wrongly enjoined the sixth respondent, His Excellency the President, when Article 143(2) is clear that no civil proceedings can be instituted against the President. A decision that has been affirmed by the Supreme Court in the decision of Attorney General and two others versus D and 79 others. So the Supreme Court made an express order that the President cannot be sued. It's an order. So the pleadings that have been lodged before this court have been filed in contempt of the Supreme Court decision, and they should amount to nothing in the full and final set of facts. So I'll be seeking that the bench continues to stay put, so that as early as possible, I can seek to have the sixth respondent discharged from the irregular proceedings initiated by the petitioners, and which they don't want concluded. They want to thrust this country into a crisis. Under Article 146, there is possibility of the office of the President becoming vacant on account of various issues, either through death, which is uncertain, through resignation, because he can tender resignation and decide that I think I've had it too much, he can tender resignation, or any other reason that may arise. So at the moment, upon the Senate voting on the first ground of impeachment, we stood without a deputy president. So what would happen in the event we have a vacancy in the office of the president? We are staring at a crisis. We don't have a deputy president. The Honorable Speaker of the Assembly can only serve for 60 days. We don't have an IBC. So what the petitioners are doing is fomenting a crisis of monumental proportions, which we will not be able to mind about. So I humbly pray my Lord, my lady, that you fight favor in the arguments of the respondents and dismiss the application by the petitioners. I
presume they are. But if they are over,
One of my friends, I will be referring to the judge of the right of Justice Murima.
Well, I grew up in Nakuru. I don't have the problem of a nail and an arm. So I need to